Hi, Daniel Medwed, your professor for on-law evidence. We're about to apply Rule 403 to inflammatory or gruesome photographs. I will emphasize 3 points. First, photographs, particularly in a criminal case, often have tremendous probative value. They may relate to the cause, manner, or time of death. Second, however, they also carry a tremendous risk of unfair prejudice to the defendant. Third, we will discuss how we could minimize or mitigate the risk of unfair prejudice by coming up with different manners of presenting those photographs. Suppose Mr. Smith is charged with murder. The prosecution wants to introduce photographs of the victim who's been severely maimed and is lying with a pool of blood on the ground. Do you think that photograph could be admitted against Mr. Smith? And if so, why? The answer is, of course, it depends. On the one hand, a photograph of that nature in a murder case has tremendous probative value. It alludes to the manner or cause of death, maybe even the time of death, issues that are quite significant in many a murder case. On the other hand, a gruesome photo of that nature, showing a pool of blood, suggesting that the victim has been severely maimed, carries with it perhaps a high danger of unfair prejudice against the defendant, that the jury may react emotionally. There's a concern that a jury, when confronted with such a gruesome, inflammatory photograph, may react based on their gut and not based on reason. And they'll strike out against the target of their anger, the defendant, who's sitting there at defense tables. 403 issues invariably crop up in the context of inflammatory photographs. Short of excluding one of these photographs entirely, what might be some of the ways that you could limit the unfair prejudice of the photograph while still retaining much of the probative value? Here are a few thoughts. First, you could ask questions during jury selection designed to exclude jurors who might be especially squeamish about gory photographs. You could have limits on the size of the pictures, limits on how long jurors are exposed to the pictures. You could use only black and white photographs, and you could give a cautionary instruction to the jury. In particular, you could ask a judge at the beginning of the case whether or not she wants to allow the photograph into evidence or not, because that would allow the lawyers to structure their case and their opening statements accordingly. You've just explored the application of Rule 403 to gruesome or inflammatory photographs. I emphasize 3 things. First, that photographs often have tremendous probative value, especially in criminal cases. Second, conversely, photographs also have a tremendous risk of unfair prejudice to the defendant. And third, we explored ways in which we could mitigate the risk of unfair prejudice to a defendant by altering the presentation style of those photographs. Ultimately, photographs are important, but we must be mindful of the effect it might have on the jury to react emotionally to the detriment of a criminal defendant.